Guys, you're welcome to our channel. First of all, I encourage you to like, subscribe, and comment, and share if it's necessary to you. Today we are to dive in to understand what is a contract. We have entered into many contracts. Me myself, I have got many contracts that I don't know even the number, but I don't know what it means. What is a contract? As I say, we are lucky today we have a council in the house. Thank you for liking. So, council, our concern as a public is what is a contract? What does a contract means it? Because me myself, I have entered into many contracts. My friend have got a lot of contracts, but they don't know what it means. Because what I know, everything it has the rules and regulations that governs it. So I want to help us to bring it in broad for us to understand what is this that we carry out for the public to understand.
Oh, Council, thank you very much. And we urge you to subscribe always and like and comment. So that you can get other contents that are coming. So as per the question you are asking right now, when you see the word contract, it is something that is a wide thing in this world, where you find if a person is saying, I'm going to have a contract with someone, I've contracted this, I'm in contract with this, I have a contract, I have a deal of a contract. You understand? So, in this essence, we have to put in mind that a contract, as a contract, it has its own problems and it has its good things. It is not that it is bad itself, but it's how people handle it. You find they are getting problems because they fail to handle it in the right way, in a legal way. But by the definition, a contract is something that is an agreement that is enforceable by the law, and it is governed by the Contract Act 2010.
Okay.
And in this way, you have to understand a contract, it must be of three forms. I mean, it have to be in a process of three things. One, there must be what we call an offer. That person bringing to you the offer, I've come to you, I've said, Chef, you know what? I have something, I have a gig, I have a deal. Then you say, how can I enter? I tell you, you can enter like this, this, and this. I have this and this. So, do you agree? Then there, I'm doing what we call acceptance. I'm tabling an offer for you to accept. Then at the end of it all, you accept by the way of consideration.
Oh,
That thing that you say, now I have agreed, let's write. Oh, I have agreed, let me do what you have told me to do. Then that is consideration, something that come back by the end of the offer. The offer must return in the sense of consideration. Sometimes it is writing the agreement, writing down, signing the document. So you have to understand that way. But again, you have to put in mind that there was a case of Carbolic career versus Carbolic smoke bar. It's a common law case that we use to explain the law in our RHs when we are in LLB. So
it's
career versus Carbolic smoke bar company limited. So that case, someone tabled an offer and said that whoever could feel that he has that mind of thinking that our drug does not work. We have an offer. If you buy our drug and it does not work, we can compensate you. Then one person came in and said, he went in the back, he posted the money, and he said he went ahead and buy the drug. He used the drug, and the drug didn't work out. Then he go and sued. Then the other was saying, you know what? How comes we never write anywhere? But the court said that thing of going in the bank and post the money and went ahead buying the drug and using it, how much it did not work, it was acceptance from the offer. So that company was liable giving the offer
without even writing down.
Yes, because as per the three forms, I mean for the three ingredients of a contract: offer, acceptance, and consideration. They stood up, they showed the thing. Now, when you have to understand, there are people who can say, "Can I sue you?"
Yeah. There are people who say, what happens? They say that if there is something wrong in a contract, who can sue? For example, I may have I've been dealing maybe I have my boutique whereby I'm selling. I have the poster representing that I sell iPhones, which is an extent for you come at that boutique and you get a phone. Reaching at your home, at the end of it, you discover that what was an iPhone in your mind, it's a Samsung. So my question is, what happens if at all there is a wrong? Because most of us, we have been in such circumstances, such encumbrances, whereby we have suffered, but we have nowhere. We don't know what to do.
So counsel, the law, the privilege contract explains it, and it tells us that only parties are the only parties in the contract are the ones to sue. So you cannot sue for your friend. But there are some other instances where you find, however much, I'm not in the same contract, but I can sue you.
Sure.
Yes, it's very true. Because when you find, I may say, give me or lend me money. And I say, the other person will pay you, person B will pay you. And you fail to pay, or the other person fails to pay. I can sue the other person you told me to pay. However much is not part of us, is not part of the parties. So I can sue that person. So it is very clear. But the law basically stipulates and says that only people, parties in a contract can be sued or can sue, not from a person outside.
So somebody who is not part of my contract who is not part of our contract cannot sue in law.
Yeah. Okay. Another thing, when you hear a word contract, sometimes it can stand as a contract. Very true. But some circumstances, we have to understand that a contract, it must be varied. However much being varied, it can also be voidable to some extent.
What is voidable?
To be voidable is like we've been in contract, me and you. But again, we find there are some things that are not sorted now, not good, and the law is protecting me to come out to say no, I should not be in this contract, and the law is protecting me. Take an example. We are under marriage. I have a wife, but the law is saying you must be 18 and over. But if the person, let's say the woman is under 18, the law protects her to withdraw from that marriage because that person had no capacity to enter into marriage. So in such essence, the law protects.
So my question is, counsel, I can enter into a contract whereby in the due process I discover that I will not bear with the obligations. Can I end that contract? Anyway, how can the contract come at an end?
A contract can come to an end. However, we have what we call vitiating factors. And these vitiating factors, they promote the contract to get an end, or to treat the contract as the way it should be. Take an example. If you find that there is mistakes, there is what we call if you find that there are certain things like a mistake, coercion, frustration, dress.
Mm.
Those things can sometimes lead the contract to be nullified.
Cause there, cause there are situations whereby uh, you can enter into a contract with somebody. Maybe uh, I enter a contract with you to give me your room to act as a store whereby I may have entered into with you to put there like sorghum, and from nowhere the fire comes and the house is burned, and my sorghum is taken and even the house is destroyed. Can we handle such situation? How can we handle such situation if at all a contract?
Now, when you see in the case of Saul versus Butcher,
Yeah.
Lord Denning
Mm.
uh, explained the rule, the general rule, and they say that why you find that there is, let's say, a mistake will not validate or will not stop the contract if there is a mistake. But it is not. It has some exceptions. However much, yes, the general always carries some exceptions. But in this essence, you have to understand that a contract stands in two forms, or a contract, it must be uh, based on some principles: freedom of contract and the caveat emptor. What do I mean? Freedom of contract is you are free to enter. So sometimes when you enter the contract and you've been read the obligation and rules, then you have to abide with them because you've been free to enter now. Now it means after you entering that, now you are ready with the law inside it. The caveat emptor principle, for it explains that you should be aware of what you're going to buy. You are entering into a contract, but you must first read.
I have to take due diligence.
Understand, take due diligence, know what are they tabling to you.
So if I don't take due diligence, it's up to me.
It's up to you that the law of caveat emptor will be against you.
Okay, thank you, Counsel. What with you explaining all about this, can we have remedies if at all maybe the contract has been breached? The court can provide us with some remedies. For example, if at all they have breached it.
Yes, where there is the law carries the remedies because the law in the society is always to protect the people of the society. So it means giving the remedy over the breach of anything. So, but before that, you have to understand there is what we call documents. Basically, in contract, there are documents signed and unsigned. That a document that is signed, it's where. That's why I've told you the caveat emptor that people tabling you the contract, that you enter into this contract, the rules and the procedure underlined here. The last space is showing that I, Brighton, I agree to do this and this and this. When I sign without reading or understanding what the contract is saying, and I sign, then I get a problem, then I will be caught by this principle.
It's up to me.
It's up to me. An assigned document, basically, there are those documents that they will not give a space for you to sign. But in the same essence, you will find that you have to first know what is its purpose. Yes, the document is given to you. Take an example. I can give you a ticket to enter into a stadium and watch football. But the ticket has its rules and regulations. It's saying that by this time you must be out, or you must take this path, or when you reach this, you must pay this, or you must get this and this and this and this. So, which means that you taking it, we presume that you understand the procedure, the protocol. Yes. Now, when you say the remedy, the law must provide the remedy because that's the use of the law. First of all, you have to understand that the law gives several kinds of remedies. Take an example: injunction. Injunction, the court will order will give you that order to perform the task.
To perform the task that you were given to do so.
Yes. You may have breached the contract.
In injunction, meaning the court can even refrain me from the contract.
Yes, very true.
Okay.
The court has powers to do anything that is right.
Okay.
We have another thing that specific performance. Thing that you're supposed to do. You're specified to do.
It forces me to do what I was supposed to do.
Yes. Now the contract of ours is telling us, Chef, you have to pay 100,000. But for you never paid even a single coin. Now the court will come out and say, Jeff, go and pay this money in this time, this period. So that is a specific performance. We have the basic thing, the employment law. Employment law, the labor laws and other laws. Basically, when you see the Employment Act, Section 2(2), for it explains and gives that where the employee is given a job, take an example, then that employee should be given that better care, treatment. He or she should not be mistreated. Yes, however much you have entered into a contract, but now you have to be protected by some laws. So the Employment Act, it is a big thing that can
meaning
protect
that even if I be in the chambers of the employer, I am protected by the law.
You are protected by law. First of all, the welfare of yours.
If I'm mistreated, I can sue the employer.
This law, the Employment Act, for it protects the welfare of the employee in the workplace. Last but most importantly, there is what we call express and implied terms, and you can call them conditions, basically in Supply Services Act. So implied terms and express terms. Express terms are those rules written for you to guide you.
That are expressed to me.
You have reached in the press, they are saying, take this path. You are supposed to do this and you are not supposed to do this.
Meaning that if at all I'm in a contract, express terms, those are terms that are expressed to me.
They are given
that
to
your obligation is ABC.
Yeah.
What about implied?
Implied, they are not expressed, but they presume that you know them. Take an example. If they say that this is the company, they presume that the company starts to work early in the morning.
For me, I come in the evening.
You come in the evening.
Even if it was not listed.
That will not guarantee. So,
thank you guys.
So thank you for watching and listening. We love you. So subscribe and comment.